Imagine waking up one day and finding out your vote doesn't count as much as your neighbor's because of your skin color. Sounds like a dystopian nightmare, right? Wrong. It's happening right now in America, and it's the explosive core of Louisiana versus Callais, a Supreme Court showdown that could rewrite the rules of our nation. Callais involves the question of whether Congress, through the Voting Rights Act, can require special voting districts to ensure minorities' votes count, often at the expense of other people's votes. This isn't some dusty legal footnote. It's a battle for the heart of our nation, testing whether we stand by the Founding Fathers' promise and Martin Luther King's dream, a country where character trumps color. For decades, we've been trapped in a twisted game, fixing racial wrongs by obsessing over race, turning voters into pawns on a checkerboard of skin tones. The Constitution says no way. It's time to hit the reset button and fight for what made America great, equality. No excuses, no exceptions. Politicians have turned voting maps into a social experiment, sorting us like cattle based on race. But here's the kicker. The Constitution doesn't play that game. It demands equality under the law, not racial handouts or headcounts. Louisiana versus Callais is asking the question every citizen should care about. Does drawing districts by race shred the Constitution? Spoiler alert, it should. We've got laws like the Voting Rights Act forcing states to see color first, but you don't fix racism with more racism. Chief Justice Roberts nailed it. The way to stop discrimination on the basis of race is to stop discriminating on the basis of race. It's time to ditch the madness and take back our founding principles. This isn't just about squiggly lines on a map. It's about what America stands for. Do we want a nation where your race calls the shots on your vote, or one where you're heard because you're a citizen? Louisiana versus Callais is our chance to pick the right side, to kick the divisiveness of the past to the curb, and build a future where character, not color, rules. Louisiana got strong-armed into drawing a majority black district, twisting the state into a gerrymandered mess that looks like a snake on a bender. This case is an opportunity to end our nation's racial tug-of-war and demand one standard, equal justice for all. To get there, let's examine what's going on in this case and in voting rights litigation. The Voting Rights Act of 1965 was a landmark law aimed at squashing racist voting practices. It outlawed things like literacy tests and racial gerrymandering that diluted minority votes. In 1982, Congress beefed it up to prohibit vote dilution. That's when map drawers slice and dice minority communities so their voting power is watered down. But as it turns out, that can be pretty hard to know when that happens. Section 2 of the law specifically bans any voting rule or district map that discriminates on the basis of race. In plain terms, the law says you can't redraw districts in a way that minimizes a racial minority's chance to elect someone. To enforce that, courts developed a sort of checklist to see if minorities should get their own majority district. If a minority group is large and compact enough, politically cohesive, and usually thwarted by block voting from the majority, then voila, the state might have to create a majority-minority district for them. The intention was noble, I guess. Stop schemes where minority voters are, quote, cracked, spread thin across many districts, so they're never a majority, or packed, lumped into one bizarrely shaped district to isolate their influence. But here's the awkward part. Making all this happen usually requires map makers to think in racial terms. It can lead to some crazy-looking districts drawn because of race. In other words, a law meant to end race discrimination in voting sometimes encourages race-based line drawing. Talk about irony. This isn't the first time the Supreme Court weighed in on race and voting. Back in 1993, Shaw v. Reno kicked off a revolution in redistricting law. North Carolina had drawn a snake-like district that wound its way along I-85 just to corral black voters into a second majority black district. Several white voters cried foul, not because anyone was denying black votes, but because the state used race too overtly in drawing the lines. The Supreme Court agreed that if a district is so bizarre that it cannot be understood as anything other than an effort to separate voters by race, it probably violates equal protection. In Shaw and subsequent cases, the court said racial gerrymandering, drawing districts predominantly on racial lines, is unconstitutional unless it passes strict scrutiny, a super high bar to justify using race. In simpler terms, if race was the #1 reason for a district's design, the court's going to be very skeptical. Unusual district shapes became a red flag for unconstitutional racial sorting. Think about that. Congress was pushing states to create minority-majority districts, but the Constitution, by the 14th Amendment's Equal Protection Clause, was saying, not so fast, you can't racially gerrymander, even for good intentions. It's a classic legal catch-22. The Supreme Court has spent decades threading this needle, allowing consideration of race to comply with the Voting Rights Act, but not too much consideration. How much is too much? Well, that's been the issue in case after case. And the trend in recent years is the court moving toward a colorblind interpretation of the Constitution. Essentially, the idea that government shouldn't be in the business of sorting people by race at all. Fast forward to today's battle over voting districts, and you can see where this is heading. The Constitution's Equal Protection Clause guarantees equal treatment under the law for every person. That's pretty much the embodiment of MLK's content of character ideal in legal form. Our 14th Amendment doesn't say equal protection except when you think you have a really good reason to sort by race. And the Supreme Court has reminded us, in cases from Brown v. Board of Education to more recent ones, that the core purpose of equal protection is doing away with all governmentally imposed discrimination based on race. In short, racial classifications by the government are inherently suspect. So if a federal law, like the Voting Rights Act, seems to require states to sort people by race to draw districts, that law sits on a constitutional ticking time bomb. Remember, the Constitution is the supreme law of the land. If a statute conflicts with it, the Constitution wins. As far back as 1803, the Supreme Court declared that all laws which are repugnant to the Constitution are null and void. In other words, Congress can't invent a voting rights scheme that tramples the 14th Amendment's promise of equality. Enter Louisiana v. Callais, the case now in the Supreme Court spotlight. Here's the scoop. Louisiana's population is about 1/3 black, but until recently it had only one majority black congressional district out of 6. After the 2020 census, civil rights groups argued the state needed 2 such districts under the VRA's rules to give black voters a fair chance to elect candidates of their choice. A court agreed the old map likely violated Section 2 of the law by diluting black votes. So in 2022 to 2024, the state went back to the drawing board to create a second majority black district. And boy, did things get a little wild. In 2024, Louisiana's legislature special redistricting session produced some strange bedfellows. Black Democrats who wanted that second black majority seat teamed up with some white Republican legislators who had their own political axe to grind. The result was a ridiculously elongated district stretching from Shreveport, all the way in the northwest, all the way down to Baton Rouge, zigzagging through the state to grab as many black voters as possible. If you're picturing a salamander or a snake, you're not far off. Chief Justice Roberts literally described the new District 6 as a snake during oral arguments. It wasn't pretty, geographically or legally speaking. Now, a group of non-black voters from Louisiana, led by a plaintiff named Philip Callais, filed a lawsuit complaining that this remedial map discriminated against them. Their argument, the state intentionally sorted voters by race to create the new district, and that race-focused sorting violated their right to equal protection. In other words, they felt their voting rights were being limited or shuffled around purely due to race, which is exactly the kind of injury the 14th Amendment forbids. These plaintiffs basically said 2 wrongs don't make a right. You can't racially gerrymander now just because someone racially gerrymandered before. The case made it to the Supreme Court, and here's the kicker. The court didn't issue a decision last term. Instead, in June of 2025, it took the unusual step of holding the case over for re-argument next term. That's a rarity and a sign of high stakes. Even more, the justices reframed the core question to cut to the chase. Does a state violate the Constitution by intentionally creating a second majority-minority district to fix a Voting Rights Act problem? In essence, can a cure mandated by the Voting Rights Act be unconstitutional? This is potentially historic. If the court answers yes, it could declare that the law's race-conscious districting requirements conflict with the 14th Amendment. That would undermine, if not eviscerate, a key part of the Voting Rights Act. Keep in mind, the Supreme Court just last year surprised a lot of people in a different case, Allen v. Milligan. In that Alabama redistricting case, the court upheld Section 2 of the law and ordered Alabama to create a second black majority district. It was a shock because many expected the conservative majority to weaken Section 2, but Chief Justice Roberts and Justice Kavanaugh joined the liberals to affirm it. Now with Louisiana v. Callais, the court appears to be revisiting the issue from a fresh angle. As one voting rights advocate noted, courts have never before said there's a conflict between the VRA and the Constitution. If the Supreme Court now does a 180 and rules that complying with Section 2's race-based districting violates equal protection, it would be a head-spinning reversal, basically the court undoing its own precedent from just a term ago. So why would the court even consider dropping this hammer? 2 words, equal protection. The argument in favor of a colorblind constitution goes like this. The government should treat all citizens as individuals, not as members of a race. Classifying people by race, even with benign motives, is a slippery slope. As Justice Thomas often points out, discrimination is never benign. Policies like race-based districts stigmatize minorities by implying they need special treatment to succeed and breed resentment among others. And as highlighted earlier, even Chief Justice Roberts has zeroed in on the principle that to stop racial discrimination, government must just stop using race, period. In the context of voting maps, that means no more racial gerrymandering, whether it's done to hurt a minority group or to help one. Critics of the colorblind approach argue that ignoring race doesn't magically make inequality disappear, and that race-neutral policies can perpetuate the status quo of racial disparities. They point to the very reason the VRA exists. History shows that without safeguards, minority voters often get shafted. But the rebuttal is sharp. Fine, protect everyone's voting rights. Just do it without separating voters into categories by race. After all, the 15th Amendment already guarantees no one can be denied the vote because of race, and the 14th guarantees equal protection. Those are bedrock constitutional protections that outrank any statute. If a policy ends up pigeonholing people by race, even for a well-intended goal, isn't that a bit like judging by skin color, which is exactly what we're not supposed to do? Let's put it this way. The Constitution is superior to laws of Congress. If Congress, through the VRA, told Louisiana, draw a second black district or else, in doing that required the state to racially sort its citizens, then we have a showdown between the law and the Constitution's promises. And in that showdown, the Constitution must win. As the Supreme Court said long ago, an unconstitutional law is in legal contemplation as inoperative as though it had never been passed. In plain English, goodbye Voting Rights Act. The Equal Protection Clause is a guardrail that even the most righteous legislation can't smash through. This case could mark a pivotal step towards a truly colorblind approach in our democracy. Remember MLK's dream and standard, a society judging individuals by character, not color? For decades, our election laws tried to answer racial discrimination with racial classification, a move that might have been well-intentioned but is deeply paradoxical. Now the Supreme Court is poised to say, enough. Equal protection is exactly that, equal for everyone, no ifs, ands, or buts. Racial gerrymandering was wrong when politicians in the past did it to dilute minority votes, and it's still wrong if done in the name of minority voting power. 2 wrongs don't make a right. This is personal. It's about reclaiming what we've lost, not just in courtrooms, but in our national DNA. Martin Luther King didn't march for a nation where race still calls the shots. He dreamed of one where character reigns supreme. We've strayed from that. For too long, we've let the ghost of slavery and segregation trick us into thinking racial boxes are the answer. They're not. They never were. Racial gerrymandering was a crime when it silenced black voices in the Jim Crow South, and it's still a crime when it's dressed up as progress today. Louisiana v. Callais is our shot to break that cycle, to say we're done. No more dividing, no more classifying, just equality, period. If the court rules that race-conscious disagreeing violates the Constitution, it doesn't mean abandoning minority voters. It means states must find race-neutral ways to ensure fair representation. It means we uphold the principle that fundamental rights, like the right to vote and have your vote count equally, cannot be infringed for social engineering, however noble the aim. We've sacrificed a straightforward principle of equality for too long on the altar of correcting past injustices. Perhaps it's time to realign the law with the Constitution's true north. After all, judging people by their skin in any context was never the end game of the civil rights movement. In the spirit of Dr. King, it's to let character and merit, not color, be our guide. Louisiana v. Callais isn't just a case, it's a reckoning. A chance to reclaim the heart of American justice from the tangle of good intentions gone wrong. To turn the page on division and write a new chapter where equality isn't negotiable. This could be it, the moment we stop stumbling and start standing tall, proving to ourselves and the world that America can still be the land of the free, where character, not color, is king. That's not just a step forward, that's a giant leap toward the country we were always meant to be. I'm Benjamin Barr, and I'm thankful that you joined us today. My job as a constitutional litigator is to give you the tools necessary to solve today's constitutional controversies. Be sure to like and subscribe on the channel. It really helps my educational project. And tune in next week as we tackle yet another constitutional controversy.